Hello everyone and welcome to our latest webinar from UCU. I'm delighted that today we are here to discuss issues around the EU settlement scheme and that we are joined by two experts in the field from Bindmans lawyers. That is Ashley Fleming and Abigail Evans. Welcome to you both and thank you for joining us. Obviously, as many of you will know, UCU represents an awful lot of migrant members, and we've recently increased our representation of migrant members within our equality structures. And we know that there are various different challenges facing migrant members, not least the recent changes to the UK immigration scheme arising from Brexit and its results. And the EU settlement scheme is obviously a very key and core part of that. So I know that lots of you will have outstanding questions about that. I'm hoping that many of you might also have applied and have got either pre-settled status or settled status, but there may be others of you out there who haven't. And today is really just a chance for us to address some of the questions which have been submitted in advance. And also just to sort of run through some of the key aspects of the scheme. And as I say, to hear from Ashley and Abigail with all the wealth of their experience. So as we go through, we will be doing a little bit of an introduction to the scheme. We'll be talking about some of the questions that have been submitted to us in advance. But if you do have other questions or comments to make, please do feel free to use the comments box. And if we've got time, we'll certainly try and pick up any of those that we can. But I'm going to leave it there, and without further ado, hand over to Ashley and Abigail to give us an introduction, and then we'll move into some questions. So over to you guys. Thank you.
Thanks very much, Jenny. So just to introduce Abigail and myself, first of all, my name is Ashley. As Jenny said, we're both solicitors at Bindmans, and we deal with all aspects of immigration law. So what we wanted to do is start off today by just giving you a brief overview of the EU settlement scheme, which I'll refer to as the EUSS, just for shorthand, to give you an idea of what is required, what important key dates are, and hopefully deal with some of the questions that you might have in relation to the scheme. So first of all, the most important thing to flag up and to understand is that free movement has ended. So free movement ended when we left the EU following Brexit, although we did have a period of transition until the end of December 2020, which basically married over the rights of European nationals to remain in the UK. Then we had the introduction of the grace period regulations, which provided a period for European nationals and their family members to basically make an application to protect and secure the rights of residents beyond the 30th of June 2020, which is the current deadline for the majority of individuals to make an application to the EUSS. So I think the most important thing today for anyone to take away with them is to make an application to the European settlement scheme by the 30th of June 2021. And to be honest, I mean, I would do it if you haven't already done one. I wouldn't wait until the 30th. I would get one submitted now. So in terms of the scheme itself, there's some really important eligibility criteria that we need to flag up, and that is to understand who is eligible to apply to the scheme. And it's not just people that have been long-term residents in the UK, so it's European nationals who and their family members who have been resident in the UK since before 11 p.m. on the 30th of December 2020. So that's a really important date. It's 11 p.m. on the 31st of December 2020, which was the end of the transition period. So anyone who was resident here by that date should be eligible to apply, provided there's not any issues with their suitability with regards to past criminality. And what's really important is that the individual has been continuously resident since that date, at the very least. So in terms of continuous residence, what we need to show when making an application is that someone has been resident in the UK continuously, which means not having any absences of more than 6 months in any rolling 12-month period. Now, there are situations when you can be permitted a longer period of absence of up to 12 months, but that is where you can show that you had an important reason for being absent. So, for example, if you were posted overseas with your work, whether you're absent due to a serious illness, study, pregnancy, childbirth, they're the kind of examples that are anticipated in the immigration rules for that application. So basically, anyone that falls into those criteria, should be able to make their application to the EUSS.
Okay, did you want to go ahead and we'll start with the questions that were sent to us in advance. So we're going to run through. First off, somebody asked, saying that they were an EU national who was due to begin work in the UK last year on the 1st of October 2020. They were unable to travel to the UK before that cut-off point of 31st of December 2020. They have now started working for their UK employer, but they haven't yet moved here. They're planning to move before that second cut-off date of the 30th of June 2021, and they've asked whether they would be able to apply for pre-settled status now. I'm afraid the answer is no, because as Ashley said, the main eligibility criteria is that you have to have been living in the UK prior to 11 p.m. on the 31st of December 2020. Now, obviously, we are living in extraordinary times, and there have been huge impacts because of COVID, and obviously it's had an impact on people's ability to travel and ability to renew or apply for immigration status. There was some guidance given by the Home Office about COVID-related absences, but this was limited to people who were already in the UK prior to that cut-off date. So if you haven't travelled here and were living here before the 31st of December 2020, then you're not going to be eligible. That doesn't mean that you're not going to be able to apply for leave to remain in the UK under another immigration route. So obviously the EUSS is the most attractive one because it's free and it gives you very secure status with the prospect of indefinite leave once you've acquired 5 years in the UK. But there are other immigration routes that some people may want to start thinking about if they can't apply onto the EUSS. For this particular person, the most obvious route there is the skilled worker route. Some of you may be familiar with the Tier 2 visa category, which has now been replaced by the skilled worker category. And that is for people who have been offered jobs in the UK by an employer who has a what's called a sponsorship license, so that they're allowed to hire overseas nationals, which now includes EU citizens. That route has been made slightly easier than it used to be. So it is a viable option for people that can't apply under the EUSS.
Thanks, Abby. Just to add to what Abby was saying there as well, is that those kinds of applications would normally be made overseas before coming to the UK, as you can't ordinarily switch from being a visitor in the UK into that skilled worker route. So it's worth that individual, if you're online today, you need to be having discussions with your employer regarding sponsorship.
Yes, although, sorry, to add further to that, there is at the moment a bit of scope to apply to switch if you're here in the UK as a visitor and can't return to your country because the COVID restrictions, either for you coming back in or for returning to your country, are unreasonable. And there's a bit of discussion about what unreasonable means. But if you think that that might be something you want to look at, whether you can switch from in country, you need to look at it very soon, because if the country opens up and the global, all countries open up, then that concession is likely to go away. So it's a very temporary little concession you might be able to get away with. But as Ash says, normal circumstances are that you'd have to apply from overseas.
Thank you. That's really helpful. Should we move on to the next question?
Yes. Okay, so the next question we have was from someone, which basically they were asking, what happens if I do not apply for pre-settled status before the 30th of June 2021? So again, just as we said in the introduction, the deadline in the majority of cases is to make an application for pre-settled or settled status is the 30th of June 2021. So if you haven't made an application by that date, you will no longer have a right of residence in the United Kingdom. And that is because, as we've said, both the free movement provisions will have ended, and also the grace period regulations, which covered people's permission to stay in the UK until the 30th of June, will also have ended. So with that, if you don't have immigration status, you don't have the right to live here, you don't have the right to work, and you don't have the rights that you would ordinarily have protected by your previous status as a European national. So the key message again is get your application in now before the 30th of June 2021. Now, if for whatever reason you don't make an application by that deadline, then there is some scope, albeit limited, to make a late application. Now, if you're going to make a late application, you need to understand that it's for the Home Office then to decide whether you provided a good reason for making that late application. So you've got to have reasonable grounds to show that you had that you failed to make the application in time. And it's not simply a case of you forgot. I mean, that's not a good reason. So the Home Office has expanded on what they mean and what they will treat as a reasonable ground for missing the deadline. And so this can include applications that are made by children or by care leavers, and this includes where you as a parent have made your own application and have omitted to include your child because you just assumed, for example, that their status would be protected if you've sorted out your own status, whereas in actual fact you need to make an application for your children as well as yourself. If you've got any physical or mental incapacity or have additional support needs which make it difficult or have prevented you from making an application in time. Equally, if you've been suffering from a serious medical condition or you've had significant medical treatment, that might also be a reason. But you would, for all of these reasons that we're explaining, you would have to be able to evidence why the application wasn't made in time. So, for example, if you were hospitalised, you'd had an accident and you were unable to make an application, or perhaps you've had COVID and that's led to a period of hospitalisation and subsequent recovery, which left you unable to basically function as normal, then you'd want medical evidence from your doctor to show that. Other scenarios is where someone has been a victim of modern slavery, or perhaps they were in a controlling or abusive relationship. So perhaps they are with a partner who, by way of control, retains their passport, for example, thus making it difficult for them to make an application. And then if none of those sort of more serious examples apply to your situation, then if you can show there's either some compelling practical or compassionate reasons for the late application, then that might also be considered by the Home Office. So, for example, if someone says they weren't aware of the requirement, then it will be, well, why weren't you aware? Why didn't you understand you had an application to make? Were you out of the country so you didn't know that this was happening? Did you have any problems with limited access to the internet? So this is quite a digital status, which is very new. So did you have problems in making the application? Or as an individual, do you have limited English language ability, or are you not computer literate and didn't then have the right support network to assist you in making the application? So it's all about the applicant demonstrating that they had a good reason for basically applying late. And then it'll be for the Home Office to consider whether they accept that reason, and if so, grant the application.
Okay, so next we have a very practical question about obtaining settled, settled status. So simply been asked, how is the 5-year stay in the UK? Sorry, hello? Yeah. How is the 5-year stay in the UK calculated in practice, and what sort of evidence will be accepted or is acceptable? So the 5-year criteria is obviously to obtain settled status, which is indefinite leave to remain. There's no time limits on your stay. If you haven't had your 5 years, then you'll get pre-settled status and can subsequently apply for settled status once you've accrued your 5 years. So you'll have to have been living in the UK for a continuous period of 5 years to obtain settled status. And obviously that period of 5 years has to have started before the 31st of December 2020. In order to maintain your continuity of residence, you can be absent from the UK for up to 180 days in any 12-month period without your continuous residence being considered to have been broken. It's worth noting that the 12 months is a rolling period, so it doesn't just start on the 1st of January of any particular year. It's calculated on the basis of when you started living in the UK and then when your absences were. So you need to keep an eye on that if it's going to be an issue. There is the allowance for an individual to be absent from the UK of a one-off period of 12 months if there is a specific and very good reason. And as Ash has covered already, there are examples given by the Home Office where you are absent due to pregnancy, childbirth, serious illness, possibly for work-related reasons. There has been some guidance about absences related to COVID-19, although that guidance has been taken down and new guidance not yet put up. You can calculate your 5-year period. It doesn't have to have always been on the same type of leave under the EUSS scheme or under the old EU regulations. So if part of your 5-year period you had time spent as a family member of an EEA national or have a derivative right to reside in the UK, then that time can count towards your 5 years. And then moving on to what evidence is accepted. So there are some mandatory documents. So for example, you have to provide evidence of your nationality, so your passport, ideally. And then if you're applying on the basis of your relationship to an EEA national, you have to prove that relationship. So a marriage certificate, a birth certificate, something like that. So those are the obvious documents. And then going to evidence of residency, the Home Office will be looking for very solid documents, for example, annual bank statements, tenancy agreements, national insurance or HMRC records. And in fact, those are checked automatically by the Home Office. So if you've been working steadily in the UK for 5 years, you will have a solid record with HMRC, solid record of paying your national insurance, and they will check that themselves very easily. So that might speed up any application that you make. They'll also look at things like employment contracts, evidence of your studies. You can also submit documents such as just monthly bank statements, utility bills, council tax bills, even correspondence from the NHS, if you can show that for your 5-year period. But you have to have a look at how those documents are dated. So if that document only has a single date, for example, a gas bill, which is only for a specific period, then that only covers that period. It doesn't stretch beyond it. So you'd have to pull together quite a lot of documentation if you're only relying on correspondence. But you can have a variety of documents. So some of it can be relying on HMRC records, some of it can be relying on that correspondence. You pull together what you can. So it's worth keeping a dossier of your documents. just to make your application easier when you do come to make it.
That's really helpful. Yeah, so basically gather as much as you can, and that's a really helpful guide. So if we could maybe move on to the next question now, that would be great. I've got it here, and it's around how EU citizenship needs to be demonstrated.
Yeah, that's right. So someone's asked basically how do they demonstrate that they're EU national? They've said that they're a new EU citizen and they don't yet have a citizenship card or passport. So this question is a bit hard to answer without more information. First of all, I just wanted to flag again that what the requirements are for the scheme. So the individual hasn't stated how newly acquired this citizenship is. So remember, to be eligible to apply for the scheme, you have to have been a relevant EEA citizen, so a citizen of the EU by the deadline, and be resident in the UK. So if someone wasn't a European citizen before the 31st of December 2020 and resident in the UK, they don't meet the eligibility criteria. So that's the first thing to check, is when did you acquire this new citizenship, and was it before the end of the transition period? If it was before the end of the transition period, then the next thing to do is to consider how to make the application. So ordinarily, European nationals will apply using the app, which is the EU Exit Document ID Check app, where you would scan your European passport or your European ID card as proof of your identity. Now, if you don't have the passport or ID card, you can choose you can make an application instead using a paper application form, which is issued by the Home Office to you. And so in order to get one of those forms, you would need to contact the EU Resolution Centre to be sent by post form. So if that's the situation someone's in, they should do that now, because the Home Office, when you phone, say it can take up to 10 working days to get the form out, although my recent experience from the other week was that it took 2 days to be sent. But obviously you need to make sure you've built in enough time to get that sent to you. And then you would need to provide evidence of your citizenship. So the individual here has referenced the fact that they have a birth certificate, but that, without knowing the detail, wouldn't to me suggest that the individual is a citizen. So anyone born in the UK will have a UK issued birth certificate, but that doesn't make them a British citizen. Obviously the rules can change from country to country, but the best evidence will be if they've submitted and been granted citizenship, an application for citizenship in another country, is the correspondence from the Home Office in that country to confirm that they have been granted this new citizenship. Now, obviously, if that document isn't in English, then it will have to be submitted with a certified translation into English, so that the Home Office are able to read and interpret the evidence that is submitted with the application.
Super, that's really helpful. And I've just posted a note of the contact number for the EU Resolution Centre, which you mentioned as well, Ashley, so hopefully that will be helpful.
Yeah, just to flag that number as well. So in terms of any other issues, if somebody's got an application that they've submitted to the EUSS and it's still pending and you haven't heard anything, then phone that number. Use that to try and get an update on your case. Take a note of who you spoke to when you made the call so that you have a record for future reference if necessary.
Great, that's really helpful, thank you. Are we ready for the next question, or is there anything to add, Abigail, on that one? No. Oh, you're muted, but I think...
Sorry, there you go, now unmuted. No, I'll move on to the next question. As someone has asked if it's possible to apply for settled status under the EUSS where they already have indefinite leave to remain in the UK, but they have recently spent just under 2 years outside of the UK and have now returned. So important to note that if you've got indefinite leave to remain, that doesn't mean you can't apply for settled status under the EUSS. So the two are not mutually exclusive. In this particular case, however, it's going to depend on the individual's previous period of leave to remain in the UK, their period of residence, in the UK, before they left for the nearly 2-year absence. So before that 2-year period, the individual will have had to have been a relevant EU national and have been continuously resident in the UK as a relevant EU national for 5 years. Otherwise, you're not going to qualify for the settled status. People may be wondering why it would be worth applying for settled status when they've already got indefinite leave to remain. The main advantage is that once you've got settled status, you can be outside the UK for up to 5 years, whereas with indefinite leave to remain, it's 2 years without losing that grant of leave. So you have settled status, you can go and live in another country for 5 years as long as you come back to the UK. Before the 5 years is run over, then you don't have to apply for any sort of new grant of leave to remain. Whereas with indefinite leave to remain, it is that 2-year period. And it's also worth noting that the EUSS scheme is free to apply. There is some paperwork involved, but if your situation is straightforward, it is a fairly straightforward application to make. So it's worth applying to get your settled status, even if you're not sure that it actually is going to give you any advantage at the moment.
That's really helpful. Thank you. Super. Shall we move to the next question then? So this one is about pre-settled status and the ability to sort of spend time outside the UK whilst others with linked applications might be remaining in the UK. Oh, I think you're muted, Ashley. Are we coming? Yeah.
Thanks. So this one is quite a tricky question, and it's one that I've thought about for quite a while, so was Abby. And the reason is because my automatic reaction was to say, no, you can't. Your husband can't stay here whilst you're here. And I think that's because everything about EU law previously has been free movement rights are tied to the European nationals. So if you're not here, your family members can't be here. But what we've done is we've gone back to basics and we've looked at the European settlement scheme and the various definitions to really think about this scenario. So what we need to think about first of all is whether you will continue, you or your husband will continue to meet the requirements of leave to remain or leave to enter under the European settlement scheme during this relevant period. Because if you don't meet the requirements of Appendix EU, then that is grounds for the Home Office to curtail leave. It's not saying they will do, but the rules say if it's proportionate, in all the circumstances, the Home Office may curtail your status if you don't have, if you fail to continue to meet the requirements. So the first thing is whether you, as the European national, or a relevant EA national. So what we need to think about, are you resident in the UK and have you been continuously resident in the UK since before the end of the transition period, i.e. the end of December 2020? So you wouldn't be here on a daily basis, but are you resident here? And so we need to think about what that means in terms of your continuity of residence. And so your continuity of residence, as we've mentioned before, would be automatically broken if you have spent more than 180 days or 6 months outside the UK in any 12-month period. So if you're going to be away with your employer for 12 months, then from that reading, you would say, yes, you would break your continuity of residence and therefore you would no longer be classed as continuously resident in the UK. However, we also mentioned earlier on that you're allowed one absence of up to 12 months for an important reason, including an overseas posting for your work. So in that scenario, you would be maintaining hopefully your home in the UK, meanwhile you'll be working overseas and have that important reason so as not to break your continuity of residence. When it comes to your husband, they need to continue to be your family member, so you need to still be married, you can't be divorced, and also you need to show that your relationship is subsisting. So what you would need to think about keeping is evidence that your relationship was maintained whilst you're not here. So how often do you travel back to the UK to be with your family? What evidence can you provide of that? How do you keep in contact while you're not together? So are you WhatsApping each other? Are you emailing? What are you doing? Are you calling each other? Do we have a record of that? And then I think you would need to keep all of that evidence so that when it comes to your settled status application, not only can you show that you were continuously resident notwithstanding your absence, but that also your relationship with your husband continued throughout that relevant period.
So hoops to jump through, but manageable.
And it is for the Home Office. You know, they've got to be satisfied of all of those things when you make that application. So it all comes down to you providing the evidence. It's not automatic. It's you saying, this is the situation, here is my evidence, and them saying, okay, we accept that.
Yeah, as with so many things when related to immigration, it comes down to discretion of the Home Office. But as you said, the more evidence can be provided, the stronger the case can be made. That's really helpful. Abigail, is there anything you wanted to add on that, or should we move on to the next question?
No, I mean, as Ash said, we did have a good think about this, and we feel that we've come down on the right side, but it will come down to documentary evidence. I mean, there may be very good reasons why the individual who's remaining in the UK is staying here, for example, their own job, or if there are children in school, anything like that. So it could be quite a straightforward explanation, but the more evidence you put in to support your application, the better. For anything.
Yeah, absolutely. That's really helpful. Thank you. I think our final question speaks to something which Frank Schubert has also asked in the comments section, which is around written confirmation of settled status, and indeed what confirmation of settled status will be given. So I will hand it back over to you guys to speak to that.
Yes. So obviously, lots of people have been seeing the newspaper reports about EU nationals getting stopped and detained at airports or other ports and questioned, and in some cases refused entry to the UK. Now, obviously, that is really worrying. If we just sort of back up a little bit and go again to the basics so that everyone knows what the situation is. If you have been granted pre-settled or settled status in the UK, you don't get a biometric residence card or any physical document to prove that you've got that status. There is an electronic record of your status. Now, the UK border officials are supposed to be able to access that record, and they can check using your passport. So they enter your details, your passport details, and it screen pops up saying this person has pre or settled status. What seems to be happening is that the UK border force either don't understand the system or don't have proper access to it. It's completely likely that the two computer systems have not been merged properly, so it might just simply be an IT issue. We don't know. But what is happening is that UK border officials, in some cases, certainly not in all, but in some cases, have been unable to verify that an individual has pre or settled status, and they are then taking the simplistic view that if someone can't prove their right to enter the UK, then they're not going to be allowed in. This is obviously something that is being flagged in the media, and there are a lot of urgent campaigns for EU national EU support groups to try and get this sorted out. So it's not just going to be an ongoing problem. We hope that, in the next few months that this issue will resolve itself. At the moment, we can't offer you any sort of guarantee way of avoiding being questioned at the airport. Obviously, what we would say is if you have had a biometric residence card in the past, you might want to carry that with you. Carry your passport with you rather than your EU national identity cards. Print out a copy of the electronic record showing that you've got settled status. That's not going to get you through, but it's going to be helpful for a border force national to be able to, border force official to be able to have a look at. Okay, so you can try and protect yourself a little bit or future-proof yourself by carrying that additional paperwork, even though you shouldn't need it. Worth carrying. Also worth saying that from the 1st of October this year, if you have been used to travelling in and out of the UK with your national ID card, you won't be able to do that from the 1st of October unless you've got an EU settlement scheme family permit, something called a frontier worker permit, which is for EU nationals who live in an EU country but work in the UK, or you've got something called an S2 healthcare visitor visa, or you're a Swiss service provider. So they're very specific exceptions who are allowed to travel on their national ID card. Otherwise, you would be expected to use your passport. Okay.
Abby, sorry to interrupt. Just the fact that if you've got pre or settled status, that also counts. So you can travel in with your national ID card if you've already been issued status.
Oh, I think you've muted Abby.
Sorry, yes, Ash is right. I skipped over that, but very important to note. And then if you're an EU family member, sorry, a non-EU family member of an EU national, you should be issued with a residence card or a residence permit. The two are slightly different, but for terms of entering the UK, you'd be able to rely on that card as well as your passport to enter the UK. So family members actually have a slightly easier time of it at the moment than the relevant EU national. Just carry all the documentation with you that you can, really.
Just also to say that, there have been stories about people being stopped at the border, but that is the very small minority of cases. So the vast majority of people won't have any difficulties. Their status, digital status will work. They have a share code which they can send to employers, to landlords, to whoever needs to see their status. And the Home Office has resisted, as Abby said, challenges to this new digital status scheme. And I don't think, unless something, there then becomes lots and lots more people affected or stories coming out, I don't see that this is going to change, because the Home Office has introduced their new immigration plan going forward, and they're looking to move other nationals, foreign nationals, into this digital only status, because they've taken the view that it will provide more security for border control on that basis, because there won't be a forged document will be no use to someone if the status is digitally only, and that digital status is controlled solely by the Home Office. So I think it is the way forward, and whether people like it or not. And unfortunately, yeah, the EUSS is, I guess, a bit of a guinea pig for that. And what I would say, if anyone does feel that they're not able to navigate the system because of the digital nature of it, so you're not computer savvy, or you have relatives, particularly elderly relatives, who don't feel able to manage the system, then there is support offered by the Home Office. There's an assisted digital support service, so if people do have difficulties with that kind of side of things, then they can get assistance with making the application. Also, in those scenarios, there is also the fallback option of requesting a paper form as well, where someone isn't comfortable with using the online process.
Super, thank you. That's really helpful. I think if it's okay with you, I think that was the last of our sort of pre-submitted questions. We have had a couple of questions in the comments. We've spoken, I think, to one of those already, but if we could just go back a little bit to a question that's come in from Stefania, who studied in the UK sort of between 2003 and 2008, and sort of has spent other periods in the UK as well, but wasn't living in the UK in 2020, can 5 years, say, have been calculated? Can a 5 year stay that's sort of historic, I guess, be used as a basis for an application or not?
So the short answer is yes. So you don't have to just look at the last 5 years. Okay, so you can look at other periods of time in history. So if someone can show a prior period of 5 years residence in the United Kingdom and can provide the evidence of that, then they can make an application based on that 5 year period, provided that since the end of that 5 year period and when they would be deemed to have been eligible for settled status, they haven't then been absent from the UK for more than 5 years at a time, because you will lose your settled status if you've been away for more than 5 years. Okay, so in Stefania's situation, if Stefania had been here for a full 5 years between 2003 and 2008 and can evidence that and is entitled to settled status on that period of residence, she would then need to be able to demonstrate that she has not then been, sorry, that she's been back to the UK between 2003 and 2020, because obviously between 2008 and 2012 that's less than 5 years, so she's come back during that time frame, but since 2003 to 2020 we don't know what's happened. So you'd need to be able to prove that you had been back in the UK at some point between 2013 and 2020 in order to basically make use of that earlier period of residence as a path to EUSS settled status.
Super, that's really helpful. And I guess just to sort of come back a little bit then to the point you were making at the beginning, really, that obviously the deadline for applications for settled status is fast approaching on the 30th of June. We've talked a lot about the various aspects of that. But just can we sort of have a little recap of what happens if anyone doesn't manage to get an application in by 30th of June and where that would leave them?
Yes, so as Ash said when we were dealing with this, there may be some scope to apply after the 30th of June if you've got a really good reason. Essentially, the Home Office has published some guidance on when they will look at applications, late applications, essentially. And I've had a look at the guidance, and there does seem to be an encouragement towards the decision makers exercising discretion and being quite reasonable when looking at why the application is late. But obviously, as Ash said, it's not good enough to say, oh, I forgot, or, oh, well, I just didn't know about it. It has to be, that the individual was under 18 and thought that they were linked to their parent status. There was also a recent case that was brought about children who are in care in the UK whose immigration status has not been sorted out by the local authority, who then turn 18 and suddenly find that they don't have immigration status. If that applies to an individual and they're therefore putting in a late application, then they have their applications should be successful if they can show that they were a child in the care here. If an individual has got support needs, so limited capacity, or has been very unwell and receiving treatment, then again, that's a justification for a late application. Domestic violence, being a victim of modern slavery, all of those types of things are considered good reasons. And then you're looking at slightly less strong reasons, but also equally compelling. So where someone simply wasn't aware, possibly because of their age or their lack of ability to use the internet, to use a computer, or has very limited English, living abroad where there was no publication of the requirements of the EUSS scheme, all of those can be considered. I mean, at the moment, Obviously, we're pre-30th of June 2021, so we don't know how it's going to fall out. I think my advice would be to an individual who has missed the deadline is to give it a shot. You know, put your application in as soon as you can, and see what happens. Obviously, put in your justifications as to why it's late. Definitely better to try than to not and leave it, because the issue won't go away. Things won't get better. In fact, your position will become increasingly more difficult if you're unable to prove that you've got status in the UK. So absolutely worth trying, and not just burying your head in the sand and trying to forget about it.
Yeah. Just to add to that as well, the sooner you apply after the deadline, the better it will be for you as well. So the Home Office are more likely to be kinder to you the sooner you're applying after you've realised that you've passed that deadline. So, I mean, I think this is all really great that there's guidance out there, but the bottom line and our advice is still do it now. Don't wait. And you know, it's actually it doesn't take long at all to make this application, particularly if you're able to use the app. You know, it could half an hour and you'll be done, you know. So you might have to upload documents after the event, but at least it's submitted and you're in, you've done it in time.
And as I've said before, the application is free to make, and if you are refused, doesn't mean you can't apply again. So you might be refused because the Home Office didn't like a particular document that you submitted and they've just sent a quick no. Do it again, rectify the mistake, and resubmit your application. And you can continue to do that. Obviously, you don't want to submit 10 applications and keep getting knocked back. I think at that point, seek legal advice. But if it's a simple error that you can easily rectify, then that's great. You just do it. Just make the application. And if you are worried about your documents and think you might get refused, well, put your application in now, and then you've got time to rectify any mistake before the 30th of June. So, you know, it's the 1st of June now. You've got a month. It's not going to take you a month to make the application or to prepare the documents. It should take you, you know, a few days to gather the evidence together, then just get it in, or get it in and then make sure you've got time to get your paperwork afterwards so that you can upload it.
Yeah, that's really helpful. So yeah, just don't delay. I think it's the key message coming through very strongly from that, which is really helpful. We've had another question in from Orkeza. I hope I pronounced that right. Apologies if I haven't. Around the way in which pre-settled status translates through then to settled status, and you know the sort of whether some gaps in employment might mean that it would be better to wait, you know, for a longer time before reapplying to I guess, translate from pre-settled to settled status. So I don't know if you're able to say anything to that.
Yeah.
If not, it's maybe something that we can pick up afterwards.
Yeah. So there's you can apply. You can apply now or you can apply later, as long as if you're making the application later, you do it before the end of your pre-settled status. In terms of why you got pre-settled status, you're right, there might have been gaps in your employment records, but you can fill those gaps with other evidence. So it's not a requirement for settled status that you were working during that 5-year period. It's purely that you've been resident and continuously resident during that period. So when Abby was talking about different types of evidence you can rely on, so letters from your employer, from university, from college, tenancy agreements, annual bank statements. So there's a whole host of other documents you can provide outside of that P60 or your national insurance number. So if you've got evidence to show the gaps, normally what happens, and I don't know what happened with your first application, but normally when you apply and it says you'll be considered for pre-settled status, you've got the option to say, well, no, I actually want to be considered for settled status, at which point the Home Office will tell you, we need evidence of your residence between X date and Y. So they will say the period that they aren't able to verify from their automatic checks with HMRC. So if you've got the paperwork, then it's definitely worth giving another go. And again, it's up to you whether you do it now or you really do it later. If you've already got pre-settled status, you've made your application that you need to by the 30th of June. And so your next deadline to think about is making the subsequent application before that expires.
Great, that's really helpful. Thank you. So yeah, get creative in terms of what type of evidence you might want to provide. But yeah, whatever can show your time here is what you need. We've had another question in from Stefania in relation to periods of absence. We've talked a little bit about this already today, but if I could bring the question onto screen, it's around status might be lost after 5 years of not being in the UK, but what does that really mean? You know, is it a few days, is it a few months that we need to be in the UK every year?
There's no minimum time frame. You just need to break the fact that you're absent, but you need to prove you were here. So a ticket doesn't do that, because there's no guarantee that you actually travelled on that ticket, unless it was then subsequently stamped, for example, upon your arrival. So think about, what did you do when you were here? Did you take cash out of your bank account? Did you purchase any goods? Can you show that you were physically here on that date? So if our clients use taxi receipts, obviously bank statements, things like that, you need to physically show you're here, not that you just planned to be here, because as I say, you might not have travelled during that period.
Yeah, so as Ash said, we've had people put in what seems flimsy evidence, but as long as it shows you are physically present in the UK, then it can be relied on. So yeah, records of transactions that you've made in the UK, even if it's purchasing a cup of coffee, or staying in a hotel here, staying in an Airbnb, anything. And the financial documents are really the easiest to show, because there is always a record of things that you've bought, the things you paid for. So you can rely on those, even if it's for, you're only here for a few days.
That's very helpful. It comes back to the point around being creative, but yeah, that's really helpful to know that it's not just employment or or financial records that people necessarily need to provide. I don't think we've got any more questions, live questions. Oh, Ashley, did you have something you wanted to?
Yeah, can I just come back on something, because someone else in the chat, can't find it now, but they had another point about this not having a physical card, and so you're not going to get a physical card unless you're a non-European family member. But one thing that's really important to sort of try and avoid any issues is to make sure you keep the Home Office up to date of any changes. So if you get a new passport, if your national ID card has changed, or you've got a new one of those, you need to log into your Home Office system. When you get your letter, your settled status outcome letter, it gives you the link. You can find it online as well, and you just need to make sure you update them so that your passport that you use with the application, if that's expired, you put in your new passport number so that it's constantly tied to your valid document, because that's how the checks are done. So if you haven't updated that, it won't talk to one another, because it doesn't recognise this new document. So just always keep your records up to date with the Home Office.
That's really helpful. I guess if I could maybe just ask then if you've got any kind of closing thoughts. I guess we certainly want to reinforce that the sooner you apply for the scheme, the better. Obviously the deadline is the 30th of June. We've talked a little bit about exceptional circumstances where people might be able to apply after, but in any event, the sooner you apply, the better. But is there anything else that you would just like to reinforce as sort of closing thoughts, Ashley and Abigail?
I think the really, really key thing is applying in time before the 30th of June. And I think you'll notice a theme of my comments is put the application in, even if you're not sure. It's free, and if you're refused, you can apply again, and getting that refusal may tell you how to fix it so that you are granted. So don't be afraid to apply, even if you're not sure that your evidence is 100% correct. It's better to apply within before the deadline of the 30th of June than worry about it and not do it because you're worried about a refusal. It doesn't matter if you get refused, just apply again. Okay, so
yeah,
sorry,
the other
you want to add?
Yeah, I was going to say, if you are refused, you do have a right of appeal against that decision as well. So you might want to exercise that right of appeal, particularly if you get your decision after the 30th of June, so you can appeal and do that, and or make a fresh application. But you can try and rectify, particularly if you think that the Home Office have got it wrong or your evidence was good enough. It's definitely worth doing that, and you have 14 days to lodge your appeal from when you get the decision. So again, it's not the end. It's not the end if you get refused. You still have avenues to try and redress the decision.
Great. We've had a bit of a late question here from Stefania. We might just have time to squeeze it in. Around a question about the frontier worker permit and whether there are any disadvantages of using that instead of settled status. I don't know if that's something that you could speak to. As I say, if not, at this point we can follow up afterwards.
I think very quickly, having a frontier worker permit won't lead to settled status. So fine if that's the way that you're planning things to work out, that you're never going to live in the UK. But otherwise, the frontier worker permit is really limited. So you have to show that you've already been working in the UK. So you'll have to have met that requirement previously. So Ash, am I right? You have to have been working before the 31st of December. So it's not something you can rely on post that date. And it is just a permit. It doesn't get you anywhere. It's a permit that has to be renewed. So if you can apply for settled status, you get a lot more for your money with a settled, well, not that you're paying for it, but you get a lot more out of having settled status than you would out of having a frontier worker permit.
Yeah.
So if you've got the option, it's a no-brainer.
And I know that came from Stefania, who was asking about her previous periods of residence. So if you're not sure if you're going to get settled status, Stefania, it's still worth a shot. Like, try and make the application. If it doesn't work, then if you fit the frontier worker requirements, then you've got a fallback. But aim for the highest possible status you can get, and there's nothing to stop you if you do get settled status to come and go as if you were a frontier worker, because you're still coming back to the UK, protecting your settled status every time you do that. So you're giving yourself the option, should your circumstances change in future, where you decide you want to come back and stay here, to do that.
Super. So I think it sounds like settled status is going to be the thing that will give you the most flexibility in the future. And so, you know, if you can get an application in, get an application in now. That's all been super helpful. Thank you so much, Ashley and Abigail, for taking the time to talk us through all of it today. We know that sometimes it can feel very overwhelming, but as Ashley and Abigail have both stressed, it's not a hugely complicated process to go through to get an application in. So if you haven't done it already, you know, please give it a shot. It will be the thing that gives you the most flexibility, and you know, it's definitely a useful thing to spend half an hour or so doing. Just to quickly say, as I say, once again, thank you to Ashley and Abigail. As many of you watching will know, this is, you know, the EU settlement scheme is just one part of the post-Brexit immigration system, and we will also be holding a second webinar later this month on the 22nd of June to talk about the skilled worker route, which you know, obviously a lot of our members who are non-EU nationals in particular will be using, and so we'll be talking a little bit more about the wider reforms to the UK immigration system, and some of the things that people have been coming up against in relation to that. So please, if you are in a quality rep, or you know, you'd like some more information on that, please do come along and submit questions to us in advance. Those links were shared on our UC Equality Twitter the other day. Yeah, I guess it just remains to say thanks again to all of you for watching. Thank you to Ashley and Abigail for their time and their really helpful sage advice. And yeah, enjoy the rest of your afternoon. Thanks, everyone.